Good morning, folks. It's Nick Augustine here with Mark Scroggins. We're at Scroggins Law Group in Frisco, and today we're talking about enforcement and modification cases.
Yeah, thanks, Nick. That's something that comes up all throughout the year, but it's something that it seems like people tend to get focused on, in January an awful lot of the time.
Mm-hmm. Well, let's jump right into enforcing obligations of the divorce decree.
Sure.
What's going on there?
Well, so here's something that happens a lot of the time, like if you're talking about property division types of things. And let me back up for just a second, and so people can understand a divorce decree, as far as child support, child custody matters, is a living, breathing document. Okay, it's subject to modification. It can be changed if the circumstances of one of the parties or the kids have been changed. Those are all things that can be modified. The overriding standard is best interest of the child, but you've got to show a material and substantial change in circumstances, or if you've got something on child custody that has happened, say, within a year of the most recent order, it's a significant impairment standard. So significant impairment of physical, emotional well-being of the child, okay? So these are all things that can be done. Now, talking about enforcing obligations under a divorce decree can cover a whole lot of different areas. One of the areas that happens frequently when parties try to do things themselves is when you've got someone was supposed to receive part of a 401k or an IRA or a bonus payment, or stock options that have been exercised, or stock grants that have been exercised. Okay, so these are all areas that come into play. So like there's a formula in the family code where if you've got a bunch of options that you've received, and typically you receive options, and I'm just going to say generally you see a 4-year vesting schedule, something like that. Mm-hmm. It can be more, it can be less. Stock grants obviously or option grants are where it's just given to you at a specific strike price. Okay, but what happens a lot of the time in those scenarios, whether people have tried to do it on their own or even with attorneys a lot of the time, is it places the person who owns the options or the grants in a position of kind of acting as what is called a constructive trustee. Okay, so if I was married and got divorced from my wife, and my wife, let's say, worked for Google, okay, and so she had all these stock options, okay, I got a certain number pursuant to this, whatever we negotiated, all right, and so she's going to be sitting in the position of being a constructive trustee, meaning that I can tell her when some of these have vested, if she is still working there, if she still owns the grants or she still owns the options, that, hey, I want you to exercise these, and she needs to do it, and then I get whatever I get out of the sale of those.
Because that's all stated in the divorce decree.
That's all stated in the divorce
after final trial and everything.
Right, and so that's where people run into problems a lot of the times, because sometimes people will do this and they decide, you know what, screw him, screw her, I'm not doing a damn thing. She can come after me and get it. Well, she can come after you and get it. Mm-hmm. She can get an award of attorney's fees, and depending on what has transpired, there's a possibility that you can end up with other problems. So enforcement by contempt, which means the possibility of being jailed, all kinds of different fun little events. So there are lots of different things that can come into play on those.
Mm-hmm. What about selling the home? Is that usually something that we wait for before we have our final trial and decree, or is that something that can happen after because there may be expectations of where that equity, if any, is going to go?
Well, so just like primarily everything, okay, you and your spouse can pretty much negotiate whatever the hell you want.
Yeah.
All right. If y'all have agreed that you're going to put the house on the market and sell it prior to the final entry of the decree, you can do that. That is not the most commonplace. It happens at times. What is more common is that there's an agreement that that is memorialized in the decree that the house is going to be sold. Someone's going to live in it during that time period. Someone's going to be paying any costs of upkeep or improvements that need to be done for the purchase. It's going to cover things with the real estate agent and all of these different things, and even for the change in list price. Okay, because someone wants to list a house really high, and someone else is going, there's no way in hell that's going to sell, and they might not be incented to try to sell it, okay?
Mhm.
So typically that happens in the final decree, and that it's sold and it is delineated in there how the monies are to be either split, or what is a better situation is it's just awarded to one party, and they've got, so let's say somebody wants to stay in the house, okay? What would be typical in cases that I handle on those types of things is if the other spouse is going to receive the house, okay? They've got X amount of time to refinance it to get my client off of the note, all right? If they are unable to refinance it, then it's going to kick into a sale, okay? If it kicks into a sale, then it's going to have all these house sale provisions that we just talked about, okay? That it's, he or she might receive 100% of the funds that are generated from the sale. They might only receive a portion. It can contain all these other things like I was talking about with upkeep or additional things that need to be done to get a sale ready, okay? So all of those things are generally going to be included in that, and it's very specific. So if somebody just says, oh, yeah, to hell with that, I'm not going to do it, you can come to the court and get some relief on that.
There's a lot of moving parts in a lot of these things, and
Right.
when there's the more people, the more reins you got to pull in.
Well, and that's exactly right. And here's the problem that people also run into a lot of the time. They Google it, or they talk to their friends, and their friends tell them, well, this is what happened, or that's what happened. And guess what? If they're not a divorce lawyer, they generally don't know what the hell they're talking about how everything works. So, reach out to a board certified family lawyer, find out what's involved in these things. The money you spend on a consultation, is well worth it, and then you can make an informed decision of what, if anything, you want to do.
Absolutely.
Right.
You're right. Mark, very briefly, let's talk about enforcing child support obligations if those arise.
Sure. That is something, unfortunately, that comes up a lot of the time. So when you have a child support obligation, unless there's been a subsequent order that has been entered that lowers or raises the amount that you are obligated to pay, it is what it is, okay? If you don't pay it, an arrearage is going to begin to form. If once you are more than 30 days late, you can be enforced by contempt, which means they can make you go sit in jail for a period of time, okay? Not uncommon to hear 30 days, or someone's got weekend release or something like that. So that is something that's very serious. I mean, the state of Texas looks at it like if you were responsible enough to bring a kid into this world, you should be responsible enough to pay for it. So if you've got a child support obligation that you cannot meet, you need to hire someone to seek to modify it, okay? I hear the question, can I go through the Attorney General's office? Yes, you can. Understand, though, the Attorney General does not represent you, does not represent your spouse, does not represent the kids. The AG represents the state of Texas. It's a service that they will provide related to child support. And they are more interested when somebody is on some sort of state funding. Insurance, CHIPS, Medicare, Medicaid, stuff like that. You're receiving food stamps, something like that, okay? So if you're paying more than you can afford, you need to seek to modify it. Understand, if you are paying guidelines, okay, guideline child support, and you think, hey, I can't afford that, you're gonna have a really difficult time explaining that to a court, okay? Then something else is gonna have to give. So you can go in, you can seek to modify it, you can seek one person could seek to raise it. Let's say that somebody was making $100,000 and then they got a new job and they're making $200,000. Well, you probably want to come back and modify to seek to raise the obligation, okay? If you were making $200,000, so you were at max guideline child support, which max guidelines is based off of $9,200 right now, okay? So let's say that you've got that, you've lost a job, you've been looking and looking and looking, for the same, say, C-level suite job that you couldn't find it, had to take a middle management position, and you're making $100,000, I would suggest that you want to come in and modify it. Now, there are things that the other side can look at, saying that, you're intentionally unemployed or you're intentionally underemployed, so you need to make sure you've got all your ducks in a row. So this is not as simple as people think. There are different hoops that have to be jumped through to make sure that you're doing it correctly. So once again, like the advice that I give people all the time, reach out and talk to somebody,
Right.
okay? I mean, that is the best thing you can do. Don't go off what your friends tell you. Don't go off what you find on the web. Because a lot of the times people are pulling stuff up, and I can't tell you how many times I've heard, well, I looked this up on Google, so I know the law in the state of Texas is, and it's like, yeah, well, that's not the law in the state of Texas.
Right.
Okay, so might have been 10 years ago, but it's not now.
Right.
So,
And what county are you in? What judge? There are all sorts of
right,
different
so,
things.
so you can talk about what the propensities are of different judges, yeah,
Right.
absolutely.
All right, well, good information.
All right, here to help.
Mark, let's talk a little bit about modifying possession and conservatorship.
Sure.
All the custody issues.
Right. So that is something else that that happens frequently. Okay, the most common is where somebody's wanting to flip things, and when I say flip things, let me just back up for a second and give just a brief overview. As most people probably know, the presumption in Texas is that parents should be named joint managing conservators. Typically, one parent is going to be given the exclusive right to designate the primary residence of the children, okay? And all that is saying is that the kids live primarily with that person, okay? That has a lot of important connotations to it with, tax advantages, things of that sort, being able to, you're controlling what school the kid goes to. That's not to say that you have the exclusive right to make educational decisions. It's just talking about enrollment, okay? So that's one piece. Then you have possession and access. The minimum amount the non-primary parent is supposed to have is a standard possession order. So what everybody's heard about, first, third, and fifth weekends, there are differences between a standard possession order and an expanded standard possession order. But that's for a different day and time to talk about that, okay? So let's say that you've got a situation where you are the non-primary parent, so to speak, okay? And so you've got an expanded standard possession order. So that's every Thursday during the school year from the time school gets out, return to school the following Friday, every first, third, and fifth Friday at the time school gets out, return to school the following Monday or as soon as school resumes, okay? Alternating holiday schedule, 30 days during the summer, all right? That's an expanded. Now, let's say for whatever reason, age of the kids have become mobile, they're spending more time with you, y'all have just figured out what works best is the kids spending basically half time with y'all. Y'all started doing a week on, week off, 50-50 possession schedule. Or let's say that, the kids have gotten the other side, the former spouse is just not doing well. Let's say they've got a drug or alcohol problem and the kids are kind of in distress. You're going to want to go in and seek to modify conservatorship.
Right.
Okay? At the very least, you're going to want to seek to change who is primary. Okay? At the most, you might even want to seek to be named sole managing. When somebody is going to seek to be named sole managing conservator, it needs to be more than, the other side is an asshole is not a reason.
Right.
Okay? The other side has drug or alcohol problems which are not being addressed is a problem. The other person is an incredibly busy business person who is never around and the kids are being raised by nannies would be a reason to talk about, if mom or dad is never there, it would be better for them to actually be able to spend time with a parent who can spend that time.
Right.
Okay.
What about with blended families? When we bring new people in, there could be situations where the new kids from the new other person could be causing, there could be so many things.
Well, that's common. And so, I'm not a fan of LeVar Ball, but I do like his statement of stay in your lane on certain things. And this would be something to remember, okay? Mm-hmm. As the parent of the kids, that's your responsibility. The step parent needs to stay in their lane, okay? They are not the new daddy. They are not the new mommy, okay? Trying to force a child to call step parent mommy or daddy and doing that is an alienating behavior. You are putting yourself in harm's way by doing that. Not only that, okay, not only are you putting yourself in harm's way from the standpoint of litigation, but more importantly, you are jacking up your kids, okay? Don't do that. That's horrible. Do not do that. You need to, if you're going to remarry, and hey, I was divorced for 11 years before I got remarried, and my wife and I had plenty of discussions about, what her role was. And her role is not to be mom. My daughter has a fantastic mother. We just didn't need to be married, okay? But that wasn't her role, and she understood that very clearly, and my daughter and my wife have a great relationship. But there are some people that will let that new spouse come in and kind of take the reins and run with everything.
Right.
And that is not appropriate, okay? And you're going to get yourself in a shit ton of trouble doing that.
With a bunch of crazy kids running around, and it's going to cost you money,
Well, and
time, anxiety.
That's right. Well, the judges don't like
Possibly,
that.
yeah,
The
no.
judges do not like that. I mean, be a parent. Be a parent, okay? And that doesn't mean be the child's best friend. And there seems to be people don't understand
Or be
that.
the cooler parent because the other one has the rules.
Right. I mean, so, kids need discipline. Everybody has their own parenting style. And I'm not here to tell you what is right or wrong by any means. But what I can tell you is how a court looks at certain behavior and what is going to typically get you in trouble. And so what I can tell you is if you are not acting like the parent you are supposed to be, and you are letting your new spouse get in there and run things, and all of a sudden where things have been moving smoothly and now you've got discord or conflict, what do you think the court's going to see? They're going to see that same thing, and that's going to negatively impact you. The other thing, though, is like I said, it negatively impacts the kids. So you really, it's just harming you're harming yourself, you're harming your own kids, and so you don't want to do that.
All right. Good information.
Yeah, most importantly, if you got questions about this, because no two cases are identical, everything is different depending on what the circumstances are of your particular case. Whether it's us or somebody else, reach out and get the information you need. Do not go on what your friend tells you, don't go on what Google tells you, don't go on what somebody that just dabbles in family law tells you. Go to a board certified family lawyer, get the right information, be informed, and then make the decision that's right for you and your family.
Good advice.
All right.
Mark, my last question for today is what happens with attorney's fees in all these enforcement and modification cases?
Okay, so very distinct difference, all right? Attorney's fees can be awarded in a modification. Typically, they are not, okay? Or that has been my experience over a long damn time. Let's just say that, over 25 years doing this. It happens, but it's generally going to show that there have really been some bad acts by someone, okay? Otherwise, you don't typically see a lot of that. Now, an enforcement is totally different, okay? If you succeed on your enforcement, you're going to get attorney's fees. Does that mean you're going to get every dime you have spent? No, it doesn't. But you are going to get at least some, and a lot of the time you will get all. Now, whether or not you get all of the attorney's fees you have paid is going to be determined by really a couple of different things. One is how strong your case was, okay? The other is how well the attorney's fees are actually put on, and the reason for what was incurred, okay? So you need to make sure that the attorney or attorneys that you hire understand how to put that testimony on, what is necessary, what is required by statute, what is required by case law to show what you should be receiving in attorney's fees. There are a lot of different factors that need to be addressed, and frankly, there are a lot of attorneys that don't know what the hell they're doing with that. So, talk to someone, ask them, what is it? Let me back up. When I say talk to someone, I mean talk to a board certified family lawyer, whether it's here or whether it's with another firm, that's fine, doesn't matter. Go in and talk to somebody, but get the information and ask them, okay, based on the facts that I have provided you, what do you think my chances are of getting attorney's fees, okay? And then how do we go about doing that? What do you think, what do you guesstimate we're going to spend? And understand, no attorney can give you an absolute unless they're doing something on a flat fee, because so much is dependent on the actions of the other party. Are you able to control everything, or do you have to react to some things? Do you have to educate the other side? Does the other side have a good lawyer, or do they have someone that you have to, you either have to educate, or you can't agree that the sky is blue because they are either that difficult to deal with and are just ginning the fees, or they just don't know what the hell they're doing, okay? So you need to look at all that, and depending on what the circumstances are, how do you go about proving that up?
Well, and we talked about stock options and different things that
Right.
are, obligations in our divorce decree.
Right.
We may need to bring in experts to talk about this, that, or the other thing that is impacting the other side who says, I'm not non-compliant and dragging my feet. I have a justified reason for why I did this or this.
Well, and so I'm glad you mentioned that. So, inability to pay is an affirmative defense on child support, okay? Now, just sitting here saying I can't pay doesn't make it, okay? You have to show what actions you've been taking. So let's say you lost your job, okay? How many jobs have you applied for? Okay, just saying I've applied for 23 jobs in the last month doesn't get it.
Well,
okay?
I'm a CEO, and it's not exactly easy to walk in the door and get a CEO job.
That's understandable, okay? But also, if you were a CEO, odds are you're gonna have a pretty healthy amount of money put away, okay? So a court isn't, when you're unemployed for 2 weeks, isn't going to change the child support obligation. It's gonna take a little time, okay? They're gonna look at that. So, that's where, I mentioned intentionally unemployed and intentionally underemployed. So that's where I was talking, let's say you had a CEO job and you were getting paid $500,000 a year, okay? Which is on the low side for CEOs these days, but let's say that that's what it was. And you tried and you tried and you tried and you couldn't get anything that did that. But let's say, so you had to go in and take a middle management position that's still very well compensated, but not what you were paid before. As long as you've got the details to be able to show that, you should be okay, okay? But now we're kind of getting a little off the subject. So let me kind of come back where you mentioned the experts also with attorney's fees, okay? Sometimes if it is very convoluted on why it was necessary to spend the amount of money in attorney's fees that you did, you might want to hire an outside expert to talk about it. I would hire another board certified family lawyer to talk about the intricacies of the specific case and why this case took this amount of fees and why the court should award that, okay? That is something that we do. That is something that not many do, but some, more should do it than do. So my point is there are a whole lot of things that can be done to assist you with stuff, and every case is different. Your facts are going to be different, but ask the questions that you need to be answered, and hold someone's feet to the fire to get your answer. And understand, sometimes the correct answer is, I don't know, there's no way for me to predict that. Other times, on things, they can give you a range of what they would anticipate. Okay, so ask the questions, get your answers, and make an informed decision.
Call Scroggins Law Group.
We're here to help.
Telephone number 214-469-3100.
Or you can just send me an email, mark@scrogginslawgroup.com.
Office is available in Plano, Frisco, and Dallas, in Collin, Denton, and Dallas counties.
That is correct.
All right.
Thanks, guys.